Court is back in session. May be seated.
People of the state of Michigan versus Marcella Chidester.
All right, welcome back, ladies and gentlemen. You may be seated. Ready to make your closing statement?
Yes, sir. Thank you.
Good morning again, ladies and gentlemen. I know it's been a long 4 days. We appreciate your patience and your attentiveness. You've now seen all the evidence and heard all the testimony that you're going to hear in this case. I told you at opening that I'd come back here at closing and go over the evidence with you. There are some photos that the people did not show during the case in chief. Those will go back with you into the jury room. If you feel like those will be helpful in rendering your verdict, you're free to look through them and review them. The same with the defendant's interview. The people did not play that in their case in chief. The defense didn't elect to play it. I think the parties all felt it didn't move the needle too much one way or the other, but you're also going to be free to view that back in the jury. So what has the evidence in this case shown? It showed that Diane Medina, Leah Stiff, Ed Smothers, Jaden Phillips, and Mariah Dodds were all injured as a result of the defendant's operation of the motor vehicle. We could bring up the jury instruction on OWI causing serious impairment. And you'll have this written back in the jury room. But the injuries being the result of the operation of a motor vehicle is one of the elements you need to find. That is not in dispute. The defendant was the factual and proximate cause of those victims' injuries. Further, those injuries rose down to that element in counts 5 through 9. This is actually stipulated to by the parties. In other words, we agree the degree of injury is not in dispute. Further, to bring up what the lighthouse the evidence shows that Zane and Alana Phillips died as a result of the defendant driving that day. Their death was a factual and proximate result of her operation of the motor vehicle. They do not dispute this. You did not hear from a medical examiner because the parties agreed that that was the cause and manner of death. It is not in dispute. The defendant's willful operation of the motor vehicle is not in dispute. The parties agreed. We all saw the video of her leave her house and get in her car.
Judge, I'd agree that there's willful use of an automobile. Thought he just said we agree on willful.
No, fair enough.
I agree
guess.
there was I agree there was an automobile accident. It's proximate cause of a horrible thing of injuries and deaths.
All right, your objection is
All
sustained.
right.
People offer to you that the proof show that the defendant willfully operated the motor vehicle on the date in question. You all saw the vehicle, the video of her get into her vehicle and drive it away from her home. We think that element is met. Her identity as the driver of the vehicle is not in dispute. People would offer that there are two key elements in this case that are in dispute. The defendant's blood alcohol concentration and her intent when she crashed into the Swan Boat Club. As to the BAC, the blood alcohol concentration, you've heard from several credible, experienced, and dedicated professionals about the level of care and the quality that was taken with defendant's blood draw and the subsequent testing. You heard from Deputy Schmidt, who was able to walk you through the blood draw process and confirm that everything was done according to proper and long practice procedure. You heard from Rome Monday, the phlebotomist, who testified she had conducted thousands of blood draws in her career, and she also told you she followed the correct, proper, and accepted procedures. Former Deputy Krieger, Lab Technician Hotner testified. They both told you that not only were the policies and procedures followed, but they went above and beyond. That typically a blood sample would be dropped in the mail. This one was hand-delivered by deputy to the Michigan State Police Crime Lab. Finally, our two experts in forensic toxicology, Tabitha Faust and Samantha Beecham, testified the procedure for testing the blood and their results. Their results, that the defendant's blood was a .18, more than twice the legal limit for regular OWI and exceeding the limit for high BAC OWI. Further, there was the presence of gabapentin in her blood. But this is disputed, so what can you folks do? What other evidence can you look at to support the expert's evidence of the blood draw? First, you can look at the testimony from the first day of Ms. Sigler and Mr. Wickland. Ms. Sigler testified that she smelled alcohol on the defendant immediately after the crash. Mr. Wickland flat out called her drunk when he helped pull her out from behind the wheel of the car. He further testified he smelled alcohol on her as well. Deputy Karina said she smelled of alcohol, and Deputy Schmidt went through the field sobriety testing with you. In his opinion, she failed field sobriety testing. But how else do we know the blood alcohol result was accurate? We know because she told us. We could bring up the first clip from Deputy Karina.
To 10, 0 being like you're so cold sober you can drive perfectly, 10 being you're passed out drunk. Where do you think you're at right now?
7.
A 7? Okay.
What else supports it? When they tested her blood, they found gabapentin in her blood. What did she tell us about her gabapentin?
Run through the medications that you told me about again.
Gabapentin,
When did you take your medications today?
8 o'clock.
8 a.m.?
Yeah.
Oh.
And how do we know she had more than the one drink at Vernus? It's well established in the evidence, and I don't think either side disputes. She left Vernus at the latest at 12:15. Crash was at 3:01. But remember what she told Sergeant Bomey.
Today?
A little bit, yes.
When's the last time you had something to drink?
Probably half an hour ago.
Half an hour ago? What did you drink?
Wine.
Wine? Okay.
And just today, you heard from the clerk at Fermi 3, and you saw the video from inside the defendant's house. It's true that she had one glass of wine at Vernus. That doesn't speak to the rest of the day. All of those other pieces of evidence that I just talked about, just showed you, work together to show beyond a reasonable doubt that the drink at Vernus wasn't her first or her last drink of the day. It's similar to the mystery story I mentioned to you in Boisview, that all of the evidence lines up to show one result, except one thing. And that one thing is defense's expert. But everything else works to show that the BAC result is accurate and in line with what she did that day. The second element that people believe are in dispute is the defendant's intent. We bring up the second-degree murder instruction. For the OWI causing death and the OWI causing serious impairment, you only have to find willful operation of the vehicle and that her blood alcohol exceeded the legal limit, or that she was intoxicated, or that she was impaired by alcohol and gabapentin. For the people's first two counts, the 2 counts of murder in the 2nd degree, you have to find a separate intent. You can find one of 3 kinds of intent to find the defendant guilty of 2nd degree murder. You can find that she intended to kill. You can find that she intended to do great bodily harm. Or you can find she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her actions. As we talked about in the opening statements, you can look at what she said, you can look at what she did, and all the evidence and circumstances surrounding this case that you've heard over the last 3.5 days to decide what her intent was. You can think about her driving toward the boat club, straight as an arrow, right between those 2 telephone poles. You can think about what she said to Kristen Sigler right after the crash. Where's Don? She wanted to know where her husband was. You can think about her crashing into the neighbor's truck. And then continuing on her way. At the moment she crashed into that truck, she had to know things were not right. But she continued on. She continued on at full speed and drove her car into a 3-year-old's birthday party, into a building, a route that she knew very, very well. Ladies and gentlemen, this is not a typical drunk driving crash. Not at all. She didn't cross a center line and strike oncoming traffic. She didn't misjudge a red light and rear end someone. At almost 45 miles an hour, she drove through the wall of a building that she had been to countless times. That's what makes this worse than OWI causing death alone. She drove her car into an occupied building knowing she was unfit to operate a vehicle. And if she didn't know she was unfit to drive when she got behind the wheel, she knew it after she hit her neighbor's truck. Five, 4, 3, 2, 1. 44.3 miles an hour on a dusty, pitted dirt road. Look at all those things to determine her intent. As most criminal trials are, the focus of this trial has mostly been on the defendant. How she drove, the contents of her blood, and her state of mind. But let's not forget, a trial is about a fair trial for the defendant and for the victims. The ones you heard testify and the ones you couldn't hear testify. It's about an 8-year-old big sister and her little brother. 2 little kids that had just sat down to eat their hot dog and a cake pop at a birthday party. Sat down to have some lunch without a care in the world. They didn't have a chance. It's about justice for these 2 kids. Thank you.
Thank you. Mr. Gloves.
Thank you, Your Honor. This is, the law in Michigan says that, the plaintiff, the prosecution has the burden of proof. That's why they get to go first. That's why the defense goes second, because they don't have to prove anything. These people have to prove everything, every element beyond a reasonable doubt. And then because they have such a high burden to prove their case, they get to go first for a closing argument, that's what this is called. And then I do my closing argument as a defense. And then because they have such a high burden of beyond a reasonable doubt, they get to go again. They get to go last. So, and it's sort of common sense, we can't keep going on and on for many days. So they stop it there for long. So they get to go first, then we go, and then they get to have closing argument the last. And sometimes what happens is that they'll do their closing argument, and then they'll say something that I can't rebut or I can't stand up and talk like I am right now. I'm going to be doing with what they mentioned. So I ask all of you, when you go into the jury room to deliberate, think about what Bill Clovis would have said. Think of how I would have countered anything if they're holding anything for their last time to talk to you and I have to just sit there. This case, I don't have to tell you, it's very, very, it's very sad. It's very, very sad. And the facts of two children passing away, as the prosecutor said, in a setting like this, is just beyond grief. And that's why I took a moment out, maybe took my attorney jacket off, so to speak, and really gave sympathy to Mom, gave sympathy to all. I don't know if anybody hurt. I don't have vindictiveness. My client doesn't. And I gave my sympathy. And it's normally out of line to do that. And I'm glad the judge and prosecutor allowed me for a minute to do that, because I just had to get that off my chest for myself, because I can't talk to the witnesses here when we're in court. And they don't have to talk to me. It's very, very sad. You know, I'm taking a little bit longer in a closing argument today than I normally do when I have a trial or I'm involved in a trial. Because there are several counts. Well, first, all due respect to everybody injured in the poor little kids. I'll show them respect. And that's why I want to just talk to you. I'm not making things up. You know, so many times, you know, attorneys, people raise their eyes or look up when you say attorney or attorney jokes, and there ain't no joke in here. And I'm a real, real deal. When I talk to you, I'm not making anything up. Certainly, it's up to you. You're collectively the judge of the facts, all of you. And I respect that, and my client respects that. That's our American jurisprudence, our American law, is that we have, if you're charged with a felony, especially a capital felony, 12 jurors decide the case. So the judge certainly has been very nice and will release one person, a clerk will, and then the 12 of you, whomever you may be, will deliberate in rule on the case as a judge of facts. Of course, the most serious part of this case is second-degree murder. Murder charge don't get no more serious than that, at least in Michigan. A murder charge. And to me, in the law, is that for somebody to get charged every day for whatever, somebody to be convicted of murder, whether it be second-degree murder, there's an intent. There has to be an intent, or intentional, like recklessness, To me, that's intent. Okay? If I'm driving down the street on the freeway, and Bill Clovis never had a heart attack, and I have a heart attack, and somebody's changing their tire, and my car hits them, they die. There's not much intent there. I had a heart attack. What do you want me to do? I apologize. Everything that happened, but please don't charge me with murder. And that's our first part of the poor two children that died. And my client, you know, actions speak louder than words. My client, the officer says, in effect, had no record. Well, no.
Objection, Judge, I think he's arguing facts, not evidence.
Well, I asked him, I thought I asked the officer with regard to record, if I didn't, the jury heard me not ask him that.
All right, we'll allow it, but it's
Thank
a
you.
close call.
Thank you. This person doesn't drive around committing crimes. Here's this person that went to lunch. Let me back. I don't want to address everything they brought up. But it's interesting that some of the things they brought up was not what they call case in chief. In other words, when you present a case, the prosecutor, you put everything up there. Then the defense puts, you know, if there's any evidence they want or whatever to counter it or bolster their defense, then they go up there. That's how it's done. Then they waited and did some rebuttal and pulled things out of wherever. Why did they bring that in the case in chief? It's so true and so positive. Something to think about. Is it lawful? Yes, they can do that in the law. But think about common sense. That's another thing. You don't, a lot of times judges will tell juries, you don't leave your common sense outside. You leave your bias and prejudice outside, but not your common sense. You know, it just, you can have your common sense when you're in the room. That's what we all have, our life histories that we bring. That's why I like to have a little bit older jurors, because they've experienced life histories. And they can judge things because they've lived some life. And you can use that. You just can't have prejudice or bias. You can't have that. Somebody's in the defense table, they're guilty. Prosecuting my brother, I don't like prosecutors and police. No. Can't do that. You gotta start with a clean slate. Just as if somebody, anybody, family member, whatever, is being charged with something. You want them to have just a fair, clean slate to start with. That's why I asked from the very beginning. There's nothing been said. How would you find a person? Sometimes people say, well, they're charged guilty. They haven't put any proofs on it. They got to prove their case beyond a reasonable doubt. Every element. With regard to going, and they held for a rebuttal, this Fermi 3 or whatever party store, corner store, and there's this, she bought some stuff for the house, some wine and these 4 little bottles of whatever, Sutter or whatever. There's nothing illegal about that. When she went in there, I asked, is she sober? Is she okay? Yes. Did you sell to somebody under the influence? No. Thank God, I don't like to hear that. And, okay, so we've got that. They're going. And then we've got her going at 11 o'clock to Furnace Tavern. Okay. Did she drive there okay? Yes. She had an accident. She turned the corner, go down the road, country road, veer to the right. Everything go okay? Looks like it did, or else the officers would be telling us. They're telling us anything. They went and looked at something she bought at 9 o'clock or 9:05 in the morning. So, okay. So if it doesn't exist, that's a positive for my client. Remember that. They're going to bring up every negative there could be with a microscope. That's why there's 2 attorneys. We're going to bring up positive or talk about their negative. So, okay, so then she drove at about 11 o'clock to Venice to meet 2 friends for lunch. She says a sandwich. They say no. Sandwich, you'll see the receipt as an exhibit. Take a look at it. Looks like my client had a better memory on the food. And so she had the chicken chili or whatever. And she also had one glass of wine. And Verna's person, Kelly Thornton, they came here, and I'm told that she's like really a peppy person, but she was very sick that day, and and she was, and it showed. She did not feel good. I'm glad she showed in her subpoena. And she testified that she was sober. When she came in, she was sober. So if the prosecution is trying to say that she guzzled all these drinks and then went in there, you're wrong. Actions speak louder than words. You can talk all day long. The prosecution wasn't there, the police weren't there. All they're doing is surmising. And they're trying to surmise beyond a reasonable doubt. And they're trying to throw out facts like these two children passed away at a party. Absolutely. I feel horrible. That doesn't make somebody automatically guilty. You have to prove it. We don't go by emotions. So she comes in, the testimony of Kelly Thornton is she's sober when she comes in. It's just normal. She met friends, had lunch, had one glass of wine. Any other wine? No. Anything else to drink? Water. Okay? And the bill, she got the bill. They each got individual bills, whatever was paid on the credit card, thank God. There's a record of it. Exactly what my client said. And when I first met my client, she said I had one glass of wine, Bill, at Verna's when we were at Verna's. Because I said, what did you have at Verna's? She said, one glass of wine. And as a defense attorney, you listen to clients, but until it's backed up with something, either paper or something, you don't automatically, I hear it. I keep it in my head, I hear it. And then, when I see the search warrant that they immediately used, closed it off, nobody allowed in, immediately, because she told them, I went to Verna's, where were you before? Verna's. They went there, they use a search warrant immediately, and they get the receipt. And you'll see that's one of my exhibits. I only have like 3 exhibits, A, B, and C. Keep it simple. And that's one of the exhibits. If you take a look at the defense exhibit, it's got a little delta to D law school. That's what we use. And so that lines up perfect. She's trained, she said, for 20 years. She has regarding alcohol and observing and the effects of alcohol and seeing if somebody might be under the influence, not to serve them. And she didn't. And she felt she was totally fine. When she left, was she fine? Okay. What did she buy? What did she drink extra? Nothing. Okay. So we know that's solid. We know that before 11, it's solid sober. Then we know at 12:50 when she left, solid sober. In America, in Michigan, you're allowed to have a glass of wine. You're allowed to have a glass of wine. And she ate. Okay? And she just miraculously was able to drive home and go through the country road and branch on and turn and take the angle and do all that, not get stopped, not have a collision, not fall off the road and go into areas that are not the paved road. And she was able to park her car. These are all things of sobriety. That's what we look at. Wasn't parked on an angle. She didn't hit people coming home, hit people, the neighbor. So then she gets home. She's home for a couple hours, I'd say 12:15. She goes up to the birthday party at 3:02 or thereabouts. She was leaving 3:01 in the afternoon. So 12:30, 1:30, 2:30, about 2.5 hours. Then they say there are proofs, and they wait, that video, they wait until rebuttal and their case in chief. So I don't know what was in their mind, that's up to you. I don't know if they thought that maybe it's not as strong or doesn't make sense. but they waited till rebuttal. That's up to you. That's your area, that's your bailiwick. Okay, it's all about credibility. And so that's when they bring up and say, well, look at what we found, look at what, we got a video here, let's call it. The officer back up here and talk about a video that shows that she's walking around, okay, she's got that, whatever. And, maybe she's drinking, okay, right? And then she's not falling down, she's not tripping, she's not dropping things, but, maybe she's under the influence. Well, maybes don't convict. Maybes not beyond a reasonable doubt. We don't do that here in America, maybes. We don't send somebody away. Murder too. Maybe. Okay? So then, this collision happens, and you say, what? That was just crazy. You're right. It was crazy and completely out of character. Somebody's never had anything. And that makes me think that something neurological, that there's been talk, and that she went back while driving out of the driveway and went in reverse. She hit, and then hitting the arm, came back and went full speed ahead. And they're saying, the prosecution for a murder too, that she intentionally did this, that she had this intent, this reckless intent to kill somebody. Okay? Former Commodore. Reckless intent to kill someone. I swear, and I swear, much less two little kids. There's no intent to hurt anybody. Why would you put it to the floor? Why would that person testify that it's brake and paint gas for a second there? Both. Where'd that come from? So, when I'm working on this, I put a lot of days and hours in. When I'm working on this at my office, I'm looking at it, just don't make sense. Out of nowhere, somebody's going to put it to the floor. Somebody's going to put it to the floor. You go right into a building that's 450 feet from her house. She's a former Commodore. She lives on the street. Lived on the street forever, married, whatever, long time. So, they're...
Stop, the recording, stop.
It's that bad equipment that Judge Nichols has. Good? All right.
Judge, if people don't understand, the court reporter has more power than the judge, because when that goes out, the judge has to stop too.
That's true.
Well, that's why I would treat them with great respect. This sort of lost it for a second. Put it to the floor, and she's going to, they would say, is that she intentionally caused this recklessness. She intentionally wanted to go in the building. I don't know where that comes from. I have no idea. Yes, I understand what the video shows, but an intent to do that, that's insane. That's crazy, with all due respect. So then, while I'm working at my office and I'm going through things, we started getting voluminous records. And, you were told it was, I thought it was 200 pages, but he says more like 300 pages, of going through all the records of the state of Michigan and their history and their certification machine and this and that, and also all the records of acetone and all the other things that show up. And it's interesting that, and this is real pivotal part of the case, is you want that blood to be as pure as humanly possible for testing. Why? You got murder two charges. You have other charges that are extremely serious, under the influence causing serious injury. These are all very serious charges, very serious felonies. So you want everything right on the money, absolutely as perfect as human can be. So, why would I not? Doesn't cost a penny, and you do it every day with drunk drivers. As a road patrol officer, why wouldn't you take them to the station? Get a breathalyzer going. It's also closer in time. Have that done. Doesn't cost anything. Then you got the data master, whatever they were using back then, the breathalyzer. Okay, you got those results, they print out. Right then and there, not an hour, right then and there, immediately when you're born. 2, to confirm the first. If they're too far off, a third. Why would you not want to do that? Number 1, you've got fatality. Okay? Number 2 is, why wouldn't you do, and he talked about, a urine test. I'm not saying you gotta do one of those, but at least a breath test, but you could do a urine too. That's what the law says. That's what that DI 177 that he talked about, that he read, which means the right to refuse it, but you can take all these things. My client says, yes, sign this. You don't even need a warrant, they got one anyway. I'll sign it. You can take whatever blood you want for testing. Does somebody guilty do that? Does somebody feel guilty do that? Somebody scared and they're under the influence, do you do that? And I'm talking about to be a 1A. Does somebody sign and say no? Or, yeah, go ahead and take my blood or my urine or whatever? I don't think so. Again, we can use our common sense on this. So they do that, and they wait, a couple days and take it to Lansing. And then I'm very thankful to have a video of the person drawing the blood. And you know what? That speaks for itself. All of you saw that. And that's why there's 12 ultimately, because sometimes you catch something somebody else didn't catch or whatever and talk about it. And what's really great is you can ask for those videos from the bailiff to the judge for any of those videos. And they'll be, the judge put together a very nice exhibit list of the videos. So you don't have to look at all videos. You can pick out what you want to see, which is good. And so you'll be able to see, did she shake it, did she invert it 10 times? Because it doesn't cost anything to invert it more than once or twice. But I sort of, with all due respect, I sort of got the gist from her that she was okay with the prosecution, but if I started asking her anything, it sort of went downhill the attitude-wise. I don't know why, but I have no idea. I treated her very nice. But it just seemed like she was not happy to be here anymore. And all I did was ask simple questions. But that's up to you to judge that, because you can judge credibility, attitude, truthfulness. You can do all that. That's what you are. And so when I started asking her, well, you know, whatever, and she said a few times whatever, and then I said, well, you know, the video showed 1 or 2, it was done. It wasn't even done like that. She said, yeah. Okay, so, you know, sort of truth serum comes out when you tell somebody, well, there's a video and it says this, what do you think now? Well, yeah, it was 1 or 2 times. So, that's done, and the preservative is extremely important. Why am I hitting this so much? Because that's their case. Again, that's why I said, why not take a breathalyzer? And that. Nobody says not to do blood. If you're going to do blood, do it correctly. It's very important. So it sounds like she does, like she said, hundreds of thousands or whatever it was, and she just, you know, it's another day here, whatever. Well, there's 2 charges, by the way. So that's done. It's packaged and it's driven up a couple days later, whatever it is, and it's tested. and testing it, and they agreed, the toxicologists or whatever, said, you know, your test results are only as good as what you're testing. If it's polluted or it's not good, then your results are not good. Yes, somebody, they can come in all day long and give sworn testimony and say, it was a 0.18. I don't doubt that. I don't doubt that that was the result. But how did you get the result? Was there a problem with the fermentation? And something that really sticks out, other than, well, you didn't shake it, so there was fermentation, and here's Bill Clovis, he's coming up with something off the wall, that it's too many maybes there, and it won't overcome beyond a reasonable doubt. We've got proof positive, very thankful, that they have proof positive of a graft. I want you to take a look at, I believe it's Defendant's Exhibit C. I believe it's C. I only have 3. So take a look at that. And it'll show that it's more than a little bump. Take a look at it and see if it goes up like this. Acetone. That gas came out. And then they'd have you believe that the state of Michigan says it's okay to have acetone. It's all right, that commercial cleaner. A little bit of that doesn't hurt you. Insane. I mean, come up with something better than that. But it's okay. Nobody gets hurt by that. Oh, okay. Have you done ever testing on live human beings with acetone? I don't expect they have. At least this generation. So acetone, then my person, who to me came across very professional, very, in my opinion, you're the judging on the credibility of people, was sharp. He was credible. He wasn't sarcastic. No matter if the prosecution or myself asked questions, he was honest. And acetone, he said, you know, nail polish remover. That's what acetone is made up of. Industrial solvent. And what happens is, nobody says anybody put that in a blood sample, but it occurs through fermentation. It occurs that way, or something was polluted. The needle, before it went in there, had something, a microbe or whatever. We don't know. But I don't care how it got there, it shouldn't be there. It shouldn't be there at all. And if it's there, it just spoiled the results. These results are supposed to be positive and clean and accurate. You know, accurate in my opinion, you're the finders of fact. Accurate in my opinion, accurate is out of 100%, you can get it up to like 95. That's accurate. You start going below that, there's a problem there about accuracy. It's not a 51%. To me, that's not accurate. Okay? Again, we draw it back to murder 2. 2 charges of murder 2. And operating under the influence causing death. And operating under the influence of causing serious injuries. Counts there. Alcohol has to be right on the money. And I know I repeat a couple things just because of the seriousness of this case. Please excuse me. Where's the breathalyzer? Wouldn't it cost anything? Wouldn't it have been amazing if the breathalyzer said 0.01 or 0.02 and they're claiming 0.18? Boy, they'd have a lot of questions to answer. But you know what? The less testing you do, the less tests you have, the less defense attorneys have questions to. Right? So we don't want to have too much. Plus, remember, they're the ones in charge. You can't say, you know what? I want to go here, I want to go to a doctor, I want to have this or that. You can't say that. Why didn't they have the hospital do it? They had insurance. Why didn't they have the hospital draw some blood? just for the heck of it. Then you have to worry about transportation, fermentation, nothing, boom, it's done. Oh, by the way, I forgot about refrigeration. And it's supposed to be refrigerated. Might have an expiration date, but milk does too. If you put it outside, not refrigerate, guess what? Who cares about the expiration date? It's spoiled. Spoiled milk is the fermented. That's what it causes curds and stuff. I left some too long in my office and it stuck up the office in the refrigerator, baking soda in it. So, you know, fermentation is a very strong animal. It's very strong and it's aggressive. And you don't want that because you've got all these serious charges, including murder too. I want to know, if I was on a jury, that everything is properly done and there's no question whatsoever. And beyond a reasonable doubt, it's pretty close to that. That where we're at is that there's no question that it's there. All the elements are there. Everything was done properly. If things were not done properly, please don't feel that the seriousness of what occurred, I can't say not guilty. That's not fair. That's not what the law says. The law says for you to do your job, do your duty as a citizen, as a sworn-in juror. And that is, if you feel that somebody's not guilty of all the elements, and the people have not proven it beyond a reasonable doubt, all the elements crystal clear, then your duty is to say not guilty. And you say, oh my God, these people are going to be mad. They're going to say this. No, you don't do that. In America, you rule, just like the judge has been ruled. He rules. You rule too when you deliberate. Please. Your decision is going to affect my client's life. And I know by looking at all of you, and I've had a few trials over the years, that you've taken this very, very serious. Very serious. I truly mean that, or else I wouldn't say it. I've had a few juries. And actually, honest to God, some people will start nodding out. They'll start going to sleep. And it's like, I got to speak for a lot of them to come back up from over here. And that's sad. That's really sad. And this was supposed to be a long trial, initially. You know, picking a jury, you don't know if it's going to be 3 hours or 3 days. And we moved along very well. And everybody came across very honest. I think that's how we were able to do it. Plus, the judge is really good, if you haven't noticed, about keeping us reined in and moving the case along. I love that he starts at 8 o'clock, because I've been in other places, it's 8:30, and they show up at 11, the judge. So this one I can count on, that door's gonna open at 8. And that's good, because it's taken a lot of time out of all of our lives, but more importantly, we do this for a living, out of your life. And I truly want to say thank you. And I truly say thank you for being here, for uprooting your whole lives. I don't care if people are retired at home, you're still uprooting your life. And lastly is that we put such a heavy burden on you. We have a very heavy burden on you when you make your decision. However you make your decision, I will respect it. But you've got a heavy burden, and everybody has to go on living. But I want to thank you again for taking the time out to be here. There's areas I didn't cover just because you listened to you saw everything, the testimony, videos, exhibits. So I'm not going to go through every single piece. I've gone through enough, but it's my one time. I don't get a second time. If he does go up, Mr. Lorraine or whomever, please try to think what Bill Clovis or the defense would say in counter. Thank you very much, Ben. I appreciate your time today.
Thank you, counsel.
Brief rebuttal.
Absolutely.
Folks, I don't have a long pre-planned rebuttal or anything like that. I'm sure you're happy to hear that. Just like to hit on some things Mr. Clovis spoke about in his closing. Why didn't we play those videos and bring the Fermi clerk on before rebuttal? Because that's not how the prosecutor's office proves drunk driving. We prove drunk driving through the blood result. Once Mr. Clovis wanted to challenge that, I have what I believe to be other evidence of alcohol consumption. I'm gonna play that for you. I'm gonna show that to you. If he hadn't presented a case, I wouldn't have presented that evidence because I had a blood result. I agree with him that actions do speak louder than words. Her actions advert us. But that's the testimony of a waitress who saw her for a minute at 11 o'clock. I think she testified about 3 times that she did not see her leave. Countered with the testimony of a bartender who saw her immediately after the crash, and 2 police officers who dealt with it. Police officers specifically trained in spotting alcohol consumption. I also agree with Mr. Clovis that maybes don't convict. They do not. But you know what does? Lab results, videos, injured people, and deceased victims. The intent in this case was sealed. The second she put that car back in drive and continued down the road. He characterized it as intentional recklessness, but it's exactly what is written in the jury instruction. If you look at that, it is creating a situation. Once she starts to back out of her driveway with that blood alcohol content, that's the beginning of it. If she had run someone over right then and there, that's OWI causing death. What she did, that's second-degree murder. She knew from that second she was dangerous. She was in a situation where she was creating a high risk of death, and she continued on anyway. Mr. Clovis talked a little bit about beyond a reasonable doubt. The judge will explain to you what beyond a reasonable doubt is. What the jury instruction says is it's a doubt that grows out of reason and common sense. It's a doubt that grows out of the evidence or the lack thereof. So again, as I did in my opening statement, on behalf of the victims, on behalf of the people of the state of Michigan, when you go back in to deliberate, I ask you to look at everything, speak amongst yourselves, deliberate as you see fit, and when you're finished, find this defendant guilty of 2 counts of second-degree murder, 2 counts of OWI causing death, and 5 counts of OWI causing serious impairment. Thank you, folks.
Thank you, Mr. Lorraine.